A bond hearing, multiple guilty pleas, competency questions, and defendants facing years behind bars. This courtroom session has everything. But here's the real question. When the judge speaks, is it justice, mercy, or just procedure? Stay till the end, because some of these decisions might surprise you.
Good morning. Are you Jamon Adams?
Yes, ma'am.
This is 26 DCCR 0744. It looks like Mr. Adams is charged with aggravated assault with a deadly weapon, and Mr. Rojas has filed a motion asking that I reduce the bond currently set at $150,000. Is that correct?
That's correct, Your Honor.
Mr. Adams, the best you can, raise your right hand, please, sir. Do you swear?
Okay.
Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Rojas.
Hey, Jamon, how old are you?
21.
Where are you originally from?
Houston.
Okay, but when this incident happened, you were living here in town with your dad?
Yes, sir.
And your dad's the victim of this complaining witness in this case, right?
Yes, sir.
Okay. How long have you been in jail?
Since April 8th.
And the only other person other than your father that can realistically help you with this is your mom, right?
Yes, sir.
Okay. And your mom, you've talked with her and you've talked to she's unable to make a bond of $150,000.
No, sir.
Okay. Do you own any property that you could sell? A house, a car, a land? Do you have a bank account in your name?
Yes, sir.
Do you know approximately how much money is in that account?
Probably zero, maybe in the negative.
Okay. This is, again, you're 17 years old. This is the very first time you've been arrested, right?
Yes, sir.
Okay. Your mom's going to help you out with the bond if we can get it lowered. And I think maybe an aunt. He said maybe there's an aunt out there that can help her.
Yes.
Okay. Are you married?
No, sir.
Do you have any kids?
No, sir.
Okay, so it's just you.
Just me.
So if you're able to make a bond, like I said, before this, you were living with your dad. What's your plan? If the judge will let you, you want to go live with your mom in Austin?
Yes, so I will go to Austin. I already have a job lined up for myself. She's holding it down for me right now. She's also working to get her own apartment so that I can go move in with her, start working, and continue back on my plan to get back in school.
Okay. And you say get back in school. Was that high school?
No.
Okay. Where were you going to college at?
Hardly did believe from university. It's in San Antonio.
Okay. And once you're able to get this all behind you, that's your plan to get back into college.
Yes.
All right. That's what it's doing.
Just so we're clear, you're 21 years old, right? Not 17. I think that was a misstatement.
Yes.
Okay.
21, yes.
Apologize. Did I say that?
I think you said 17.
Okay.
I know it's an error.
Nice.
I have another question, Joe.
Okay. Any other witnesses?
No, Judge.
Mr. Nichols, what's the state's position?
Judge, he's accused of breaking into his own home after he'd been kicked out. And when his father tried to push him out the window that he broke in through, he grabbed a knife and stabbed him. I think 150 is appropriate in this situation, Judge.
And for the record, I am taking judicial notice of the court's file. It includes the probable cause affidavit. If you'll give me just a second, let me. So you said you would be going to Austin if you make bond, no matter what that is, and living with your mom. Is that correct?
Yes.
But that she would be getting her own place. Where does she live now?
I believe it's one of those homes where she pays for that space.
Okay.
I believe the money she's paying there, she can also pay for an apartment. So that's what she's doing while working both jobs.
And what's the job that you would have?
I would have the IHOP job. That's her second job. That's the job that I will be going to.
When's the last time you were in school?
I believe in May of 2024. That's when I left college. I couldn't keep up with the $40,000.
Speak up.
I said I cannot keep up the $40,000 on my own for tuition.
Any history that you can?
Minor juvenile, I think an arrest and a non-suit out of Harris County for burglary within a juvenile, but nothing else, right?
All right, so what I'm going to do, Mr. Adams, I'm going to grant the motion. I'm going to reduce your bond to $100,000. Condition of that bond, if you make it, is going to be that you obviously have absolutely no contact, no communication with David Keys. You will be ordered to wear a GPS monitoring device. You will be allowed to live in Austin with your mom. You would have to get that address before you go to your attorney or to your bondsman. And also, obviously, not be anywhere near the residence at 1970 Ave Street. Do you understand?
Yes, ma'am.
No contact and no communication means none. That not sending messages obviously means in person, but it also means sending any type of messages yourself or through anybody else or anything like that. You understand?
Yes, ma'am. I have no intentions.
And we'll reset it for an announcement. All right, you can go back with the bailiff.
Thank you.
Thank you. Thank you.
Good morning. Are you Kashonda Renee Riley? Yes, ma'am. Will your client waive a formal reading of the indictments and the motion?
She will, Your Honor.
Ms. Riley, in cause number 26 VCCR 0210, you're charged with a state jail felony offense of theft of property with previous convictions from December 20th of 2025. The indictment alleges that you were previously convicted of theft August 25th of 2017, and then 2 cases on March 1st of 2023. And how do you plead to that charge?
Guilty.
And are those prior convictions true?
Yes.
Did you enter your plea of guilty and true in this case freely and voluntarily?
Yes.
And did you plead guilty because you actually did what they've charged you with?
Yes.
Then, in clause number 26, DCCR 0211, you're also charged with theft of property with previous convictions, a state jail felony, and this is from November 24th of 2025. It alleges those same prior convictions for theft, and how do you plead to this charge?
Yes.
And again, are those prior convictions true?
Yes.
And you entered your plea of guilty and true freely and voluntarily,
Yes.
and because you actually did what they've charged you with.
Yes.
In each of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreements that you've reached in these 2 cases is for a cap of 15 months in the state jail prison, which means if I follow the agreement, I cannot give you more than 15 months. I can give you 15 months. I can give you less. It'll depend on the information that I receive when we come back from sentencing or for sentencing. You have an absolute right to have a jury come in and decide 2 things. The first is to decide if you're guilty or not. And then if that jury finds you guilty, you could leave your punishment up to them. If we go forward this way, you're waiving that and leaving it up to me. And is that what you want to do?
Yes.
State tenders number 1 in each of those cases.
No objection.
It's admitted in each case. Is there any evidence that Ms. Riley is not competent?
No, Your Honor.
All right, ma'am. In each of these cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset both of those cases so that we can get a pre-sentence report done. That'll give me some more information about you and the cases, and then we'll come back later for sentencing.
Yes.
And then we have cause number 24, DCCR 1778. Give me just a second. All right, this shows that you were, this is a motion to revoke your unadjudicated probation. shows that you were placed on probation April 21st of 2025 for the offense of theft of property with previous convictions, a state jail felony, and that was a 3-year deferred probation. Is that correct?
Yes, ma'am.
It alleges you violated your probation. Count 1 alleges that you committed the new offense of theft of property with previous convictions December 20th of 2025. And is that true or not true?
Yes, ma'am. It's true.
And then count 2 alleges that you committed the offense of failure to ID a fugitive with intent to give false information on December 20th of 2025. And is that true or not true?
True.
Count 3 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
Count 4 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
True.
And then count 5 alleges that you are behind in your court assessed fees. Is that true or not true? Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
I also have here on the tablet, in that case, some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over these with Mr. Rojas?
Yes, ma'am.
And you understand if I follow the agreement, which is a cap of 15 months in this case as well, that you'll be waiving or giving up any right to appeal.
Yes.
State tenders number 1.
No objection.
All right, it's admitted. All right, Ms. Riley, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm going to hold on that and reset your case for sentencing. Again, I'll get an updated report from probation and then we'll see what we get when we come back. If there's anything that you think is important for me to know, get that information to Mr. Rojas and he'll present it to me on your behalf when you come back. All right.
Judge, a first amended motion was prepared on Friday to be filed. I'm going to hold it since we've reached an agreement on everything and it won't be filed. All it did was add one of the cases she's already pleaded guilty to.
Okay. All right. Thank you. All right. You can go back with the bailiff. Good morning. Are you Cody Arnold?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Here we are.
Mr. Arnold, in cause number 26, DCCR 0488, you're charged with a 3rd-degree felony offense of harassment of a public servant from January 30th January 30th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Arnold is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the 3rd-degree felony offense of harassment of a public servant. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Do you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts? You can talk to Mr. Rojas. All right. Good luck to you, sir. You go back with the bailiff.
Yeah, go.
You're Bethany Batten.
Yes, ma'am.
And this is cause number 24, DCCR 2349. I am going to take judicial notice of the court's file. I think we've already gone through this, but just to make sure the record clear, Ms. Batten was previously found not competent to stand trial, sent to the John Dunn Behavioral Science Center for Competency Restoration, was sent back here. It looks like we got a report April 3rd of 2026 that Ms. Batten was now currently competent to stand trial. Any other issues with regard to competency?
No, Your Honor. Not from the state.
All right, then I'll make that finding that she is competent to stand trial. Will she waive the formal reading of the indictment?
She will, Your Honor.
Ms. Batten, you're charged with a third-degree felony offense of assault on a security officer, and that's from November 14th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation,
Yes.
exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. All right, Ms. Batten, I'm going to find that you entered your plea of guilty freely and voluntarily. I find again that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of assault on a security officer. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, ma'am. You can go back to the bailiff. To Dr. Grimsley.
Okay.
And just ask if this looks like just a regular psychological evaluation, which is what it's titled, instead of a sanity evaluation. And so let's get with her if you would, and we'll make a notation, but if you'll call and find out about the actual sanity evaluation, if she's able to do that. If for some reason she's not, we can get one of the other doctors to get that done pretty quickly. All right. Okay, you can go back with the bailiff. Are you DeJuan Banks?
Good morning. Yes.
This is 25 DCCR 0990. Mr. Banks is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
Judge, I've gotten some contact from some family members who are also family members to the complainant involved. I got that over to Ms. Malpino. We're trying to get that resolved and I get them in contact with them as soon as possible. They're out of state, so it's what's kind of been the difficulty.
Right. This has been. It looks like he's been in custody since October.
It's been a while, Judge. We've had some issues with trying to resolve some CPS issues. Initially, the child has also been replaced multiple. Trying to locate the child without saying too much has been somewhat difficult.
Okay.
That there is family that's involved on both sides. We also had a Garth House issue. We brought him over and since watched the Garth House. So just that final conversation, if we can some way or how, either via phone or Zoom or something, all of us together, since they're out of state, before we put it on the trial docket. Once we get to the trial docket, it's gonna be up in the air, just depending on what I'm able to do with respect to witnesses, etc. I certainly understand his having been in custody because I don't feel like the child is here locally. If Mr. Lewis wants to approach him on the issue, I don't.
So let's do this. I'm going to reset it. This will be the final reset for an announcement. Whatever you guys need to figure out between now and then, if it's going to go in the trial docket, if you file a motion for a bond reduction, I'll take a look at it. But it's definitely time to get something moving. I understand the issues that you guys have had, but it's time to do something. So this will be the last reset for an announcement.
No.
All right, you can go back with the bailiff. You, Jeremy Germain Alexander?
Yes.
And Mr. Alexander, this is cause number 26 DCCR 0178. You're charged with the third-degree felony offense of injury to an elderly individual from November 17th of 2025. Your indictment alleges that you were previously convicted of burglary of a habitation, a second-degree felony, May 10th of 2021. What that means, sir, is that if you go to trial and you're found guilty in this offense, then the range of punishment, if that prior conviction is true, would be enhanced to a second-degree felony, which means your minimum punishment would be 2 years up to 20 years in prison. Do you understand? I need you to answer out loud for the record, please. And I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for an 8-year term in prison. You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are today if you wanted to plead guilty.
Yes, ma'am.
You understand all of that?
Yes, ma'am.
You want to reject that offer and have your case set for trial.
Yes, ma'am.
We'll get that done. Mr. Smith, is there any reason to believe that there would be a change in that offer? You've got everything as far as discovery. So I want to make sure you understand, Mr. Alexander, that after today, I'll be accepting this offer unless new evidence comes up that the attorneys don't know about. You understand?
Yes, ma'am.
All right. And so, Mr. Alexander, Mr. Parker's been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
That's fine.
All right. So, Mr. Parker, you're released. Mr. Alexander, someone will be appointed today. They should be out to see you very soon to begin preparation for trial.
Thank you.
All right. You can go back with the bailiff.
From reduced bonds to prison sentences and trial risks, today's courtroom proved one thing. Every decision inside these walls can change a life forever. Which case shocked you the most? Drop your thoughts below because in court, one moment can change everything.